Hello, I am Professor Shiraditya Rakshit. This is module number 34. It talks about the African system. Basically, the aim is to understand the Charter, to examine the mechanisms involved, as also to understand the various human rights bodies concerned in the Charter and to look into various instruments for the protection of human rights. What are the learning objectives? To have an overview of the African Charter, to have an overview of the principal organs as well as the human rights bodies. Third, to examine standards and supervisory mechanisms. Furthermore, to look into various instruments for the protection of human rights. It is to be noted that the African Union AU is a regional intergovernmental organization that replaced the Organization of African Unity, or in other words, the OAU. It was established in the African Union in Lome, Togo on 11 July 2000. It became a legal and political reality in May 2001 and was officially launched in Durban, South Africa on 10 July 2002. The new organization is loosely modeled on the basis of the European Union, and it is headquartered in Addis Ababa. The OAU was established in 1963 to promote unity, solidarity and international cooperation. This international cooperation was among the newly independent African states. Now, further, in addition to this, the AU would have authority as well as the ability to achieve the economic, political integration amongst the member states by promoting democratic values. Not only that, it would also defend human rights, providing a forum for internal and regional conflict, the resolution of it. The African Union has a human rights focus that is more explicit and more expansive than the OAU. The importance of human rights was not strongly recognized under the OAU Charter. The Charter made reference to the UN Charter and to the Universal Declaration of Human Rights. The African Union Act confirms the importance of human rights. This is done by adopting of guiding principles such as gender equality, participation of the African peoples in the activities of the Union, social justice, as well as peaceful coexistence of the member states. Furthermore, there must be respect for democratic principles, human rights, the rule of law and good governance. The principal organs of the AU or the Assembly of the Union, and then you have the Executive Council, the Pan-African Parliament, as well as the Court of Justice. Apart from this, there is the Commission as well as the Permanent Representative Committee. Then you have the Peace and Security Council as well as the Economic, Social and Cultural Council. Then there is the specialized technical committees and the financial institutions. With this is the African Union Advisory Board on Corruption, which was established as an autonomous organ within the AU under Article 22 of the African Union Convention. And this African Union Convention was basically on preventing and combating corruption, which was adopted in Maputo on 11 July 2003. This was the date of its adoption. Now, what is the strength and the composition of the Assembly? The Assembly is composed of the heads of state and governments, and they meet at least once a year. It is considered the supreme organ of the African Union and as such determines, monitors and implements common policies of the African Union. It receives, considers and takes decisions on reports. Furthermore, it makes recommendations from other organs of the African Union. Now, what is the way the members are elected? The Assembly elects the members of the African Commission on Human and People's Rights and judges of the African Court of Human and People's Rights. The Executive Council is composed of ministers of foreign affairs. They meet twice a year in ordinary session, whose main functions are as follows. A. To coordinate and take decisions on policies in areas of common interest to member states. These, including or inter alia, would be foreign trade, environmental protection, humanitarian action, and disaster response, as well as education, culture, health, human resource development, and social security. Not only that, it also considers issues referred to it and to monitor the implementation of policies formulated by the Assembly. Now, what are the functions, since we have looked into the Commission? The Commission functions as the Secretariat of the AU. It is composed of the Chairperson, the Deputy Chairperson, and the 8 Commissioners. They are assisted by the Commission staff. The Pan-African Parliament, coming to that, is a single parliament serving 2 organizations, the AU and the African Economic Community, or the AEC. The AEC was established by the OAU inter alia to promote economic development and the integration of African economies. The Constitutive Act of the AU establishing the Parliament was adopted in March 2001 and entered into force on 14 December 2003. It is to be kept in mind that members of the Pan-African Parliament are elected or designated by national parliaments. Each state party is entitled to elect 5 members to the Pan-African Parliament, at least one of whom must be a woman. The Parliament has a consultative and advisory function that enables it to inter alia, discuss, as well as to make recommendations on issues relating to human rights. It is not only confined to human rights, but also includes issues relating to democracy and good governance. Having said that, let us come to the protocol relating to the establishment of the Peace and Security Council, which was adopted by the AU on 9th of July 2002 and entered into force on 26 December 2003, which replaced the mechanism on conflict prevention, management and resolution. This is basically a decision-making organ for the prevention, management and resolution of conflicts. And Its primary aim, or it's basically meant to be a collective security and an early warning arrangement to facilitate timely and efficient response to conflict and crisis situations prevailing in the region of Africa. It is composed of 15 member states. It includes humanitarian intervention, Article 5, Clause 2, Subclause A, in respect for constitutional governance, the rule of law and human rights, Articles 5, Clause 2, Subclause G, in order for the Council to function continuously. The protocol requires the Council to be represented at the headquarters of the AU at all times. This is by virtue of Article 8, Clause 1. Objectives of the Peace and Security Council include anticipating and preventing armed conflict by the virtue of Article 3, Clause B, and massive violation of human rights. Its aim is to promote democratic practices, good governance, as well as the sustainability and preservation and protection of human rights. The standby force is to be composed of standby contingents for rapid deployment at appropriate times, or in other words, when an appropriate notice is given by the virtue of Article 13, Clause 1. The functions of the African Standby Force include intervention in member state in respect of grave circumstances or at the request of a member state in order to restore peace. This is in accordance with Article 4H and J of the AU Act, as well read with Article 13, Clause 3, Subclause C. The Constitutive Act of the AU provides for an Economic, Social and Cultural Council, ECO-SOCC, as an advisory organ composed. The composition basically includes different social and professional group of the member states of the Union. This institution is meant to give the African people the possibility to participate in the activities of the EU. The Statute of the ECO-SOCC, adopted in July 2004, defines it, a few words, an advisory organ of the AU composed of different social and professional groups of its member state. Its membership shall include states as well as African social groups. Apart from states and African social groups, it also includes professional groups, NGOs, as well as cultural organizations. It is to be noted that the African human rights system is founded on the 5 treaties of the African Union, namely the African Charter on Human Rights and People's Rights and the protocols on the establishment of the Court of Justice and the Court on Human and People's Rights. Apart from that, there is the Protocol on the Rights of Women in Africa and Convention on specific aspects of the refugee problem in Africa. The African Charter on the Rights and Welfare of the Child and the African Charter on Democracy, Elections and Governance. On 26 June 1981, the African Charter was unanimously adopted by the Assembly of Heads of State. It became effective on 21st October 1986. As of December 2014, it has been ratified by 53 AU member states. What is the nature of the Charter? The African Charter is a binding treaty that covers four main categories of rights and duties, which includes individual rights, rights of people, duties of states, and duties of individual. The Charter covers economic, social, and cultural rights as well as civil and political rights. It confers rights upon peoples and not only individuals. Furthermore, the African Charter also includes a very important right, that is the third generation rights. And it gives due importance to the assumption that a person has duties as well as rights in a given community. Article 29 of the African Charter offers a list of duties, each implicitly embodying the values of African civilization. The African Charter does not contain a general derogation clause. It basically allows the state parties to suspend the enjoyment of certain rights during national emergencies. African Commission has found that legitimate reasons must exist for limiting rights, and freedoms are found in Article 27 Clause 2 of the ACHPR, namely the rights of others, collective security, morality, and common interest. While not providing for derogation clauses, African Charter contains a number of articles with provisions that limit the reach of these rights and which have been referred to as claw-back clauses. Article 9 Clause 2 ACHPR provides an example of a so-called clawback clause. It says that every individual shall have the right to express and disseminate his opinions within the law. Now, in order to understand the term within the law, its interpretation is meant that no domestic legal provision limiting the right in question could be challenged under the African Charter. The African Charter found that the term within the law was to be understood to refer to international law, not domestic law, and has stated a general principle applying to all the rights and freedoms contained in the African Charter. It is to be noted that apart from the rights and freedoms, any limitation on the rights of the Charter must be in conformity with the provisions of the Charter. That is a very famous case to be noted, the Media Rights Agenda et al. Versus Nigeria. Having said that, let us look onto the protocol to the African Charter on Human and People Rights on the Rights of Women in Africa. This was adopted by the AU on 11 July 2003 and entered into force on 15 November 2005. As of December 2014, the protocol has been ratified by 36 AU member states. The protocol addresses a variety of civil, political, economic, cultural, and social rights. Of these rights, the most important ones are Articles 4, 5, and 14. Article 4 prohibits all forms of violence against women. Article 5 forbids all forms of female genital mutilation. Article 14 assures women to a wide variety of health and reproductive rights. These rights, which are basically health and reproductive rights, includes the right to decide whether to have children, the number of children, and the spacing of children. the right to choose any method of contraception, the right to self-protection, and to be protected against sexually transmitted diseases such as HIV/AIDS. The right to be informed of one's health status and of the health status of one's partner. So that freedom is also there of understanding the partner's health. The right to have family planning education, and perhaps most significantly, the right to medical abortion in cases of sexual assault, rape, incest, and where the continued pregnancy might result endangers the mental and physical health of the mother, or in certain circumstances, the life of the mother or the fetus. This clause has represented the first time an international standard explicitly providing for the right of woman to abortion. It is also so unique that in that unequivocally right, it denounces and declares female genital mutilation and related practices absolutely illegal. The protocol particularly addresses the special needs of women. These needs arise in times of armed conflict, Article 11. In times of armed conflict, the states are required to protect asylum-seeking women, refugees, and returnees, and also IDPs or internally displaced persons from acts of sexual violence that take place within the context of armed conflicts. Not only that, it also ensures that such acts are considered as war crimes, genocide, and/or crimes against humanity. They also make sure that steps are taken that prosecution to the perpetrators of the crime proceeds accordingly. The protocol elaborates far more extensive human rights for women than any other international treaty, and this is the very unique part. The state parties to the protocol are required to submit periodic reports. The African Refugee Convention was the first African regional convention to be adopted. It entered into force in 1969 and has of December 2014 been ratified by 45 AU member states. Its most celebrated feature is its expanded definition of who is a refugee. In comparison to the 1951 Refugee Conventions, the AU definition focuses more on the objective circumstances that compel flight. The fear of danger is not linked to the individual's personnel, subjective reaction to a particular situation. It is to be kept in mind that the source of danger need not be actions of the state or of its agents. The African Union definition thus highlights the causal element. Now, what is the causal element? The causal element is of refugee situations and the jeopardy of human rights of those fleeing. Now, this is as opposed to the emphasizing the motive for flight, as is done in the 1951 Convention. It contains an absolute prohibition of refoulement that allows for no exception to be made in times of national emergency or when national security is at stake. Now, apart from the chapter on refugees, the African Union Charter of the Rights and Welfare of the Child was adopted in July 1990 by the OU Assembly. It came into force on November 1999 and was ratified by 41 AU member states. As of December 2014, the AU is the first regional organization to adopt a binding regional instrument safeguarding the rights of children. This charter is in many respects more protective than its universal counterpart. Now, what is the UN counterpart? The universal counterpart is the UN Convention on the Rights of the Child, especially with regard to refugee children, child marriages, and child soldiers. Then you have the African Charter on Democracy, Elections and Governance. This was adopted by the AU Assembly in January 2007. It entered into force on 15 February 2012 and had been ratified by 23 AU member states as of May 2015. The Charter was built on existing AU instruments and was inspired by the Inter-American Democratic Charter. This was adopted in September 2001 by a special session of the General Assembly of the Organization of the American States. Among its objectives, inter alia, is to promote adherence by each party to the universal values and principles of democracy and respect for human rights. This is enshrined in Article 2, Clause 1. The Charter institutionalizes the link between human rights and democracy. It establishes a role for the African Commission in electoral monitoring, Chapter 7, and for the AU Peace and Security Council in responding to the unconstitutional changes. These unconstitutional changes pertaining to various governments in African nations by the virtue of Chapter 8. In addition to sanctions on state parties, judicial action is also envisioned against perpetrators. This is by Articles 25, Clause 5, 9 and 10. The African Commission on Human and People's Rights was established or came into being in 1987. Under the African Charter on Human and People's Rights to protect and promote human and people's rights in Africa. The African Commission was incorporated into the AU framework at the Durban Summit held in July 2002. The Commission meets twice a year in ordinary sessions. The African Charter provides the African Commission with three principal functions. They are A. Examining state reports, Article 62 ACHPR. Under Article 62 ACHPR, member states are obliged to submit reports every 2 years on legislative and other measures. These legislative and other measures on which reports are submitted are those adopted in order to give effect to the provisions of the African Charter. The African Charter, however, is not without criticism. It failed in Article 62 to identify the organ component to review these reports. In order to remedy the situation, the African Commission adopted a resolution at its third session requesting the OUA Assembly to allow it to review state reports. The request was approved by the OAU Assembly. After the redressal, the state reports are now present to the African Commission. Like other UN treaty bodies, the African Commission has drawn up guidelines to help states submit reports that are sufficiently clear and extremely minute and detailed. The African Commission, like a commission should be, is empowered to receive and consider interstate complaints under Article 47 ACHPR. It can also consider communications alleging violations of human and people rights under Article 55 ACPHR. This provision was interpreted that Commission could only accept communications revealing a series of serious and massive violation of human rights. However, the Commission refuted this in Jawara versus the Gambia Communications 147/95 and 146/96, where it stated that it is empowered to consider any communication from anyone, including NGOs, as long as rights contained in the African Charter came into play. Recommendations are included in the annual reports of the Commission. These reports are made public once the AU Assembly has approved them. The original African Charter did not provide for the institution of a Court of Human Rights. In June 1998, the OAU adopted the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court and Human and People's Rights, which came into force on 25 January 2004. This protocol was to be replaced by the Protocol on the Statute, and this was known as the Protocol on the Statute of the African Court of Justice and Human Rights, which was adopted by the AU Summit in July 2008, with the aim of ensuring adequate resources for the operation of a single effective court in Africa. The protocol was further amended in June 2014. The 2008 protocol, as amended, was to merge the African Court on Human and People Rights and the Court of the Justice of the African Union. But the 1998 protocol would remain in force for a transitional period. This was there because to enable the African Court and Human and People's Rights to implement measures. These measures were necessary for the transfer of its prerogatives, assets, rights, and obligations to the African Court of Justice and Human and People's Rights. It is to be noted that the court's judgments are final and without appeal. It's a very unique feature. The AU Executive Council is required to monitor the execution of the judgments on behalf of the AU Assembly. The Constitutive Act of the AU provides for the establishment of the Court of Justice with an authority to rule on disputes. Disputes is of interpretation of AU treaties and for a protocol on its statute, composition, and functions. The protocol to set up the court was adopted in 2003, but is envisaged to be superseded by the protocol on the statute of the African Court of Justice and Human Rights adopted in July 2008. This created a Court of Justice and Human Rights which will incorporate the African Court on Human and People's Rights. It was to have two chambers, one for the general legal matters and one for rulings. on the human rights treaties. This all had to be governed by a protocol which was adopted in Malabo in June 2014. The court to be renamed the African Court of Justice and Human and People's Rights will have a third section, an international criminal law section with 3 chambers: a pre-trial chamber, a trial chamber, and an appellate chamber. The African Committee on the Rights and the Welfare of the Child was established in 1999 under the African Charter on the Rights and Welfare of the Child. The 11 members of the committee are elected by secret ballot by the AU Assembly. The mandate of the committee includes the promotion of the rights and welfare of the child, documentation of relevant information, the assessment of problems relating to children, the organization of meetings, the formulation and drafting of rules, and all this is aimed at protecting children and monitoring the implementation of rights enshrined in the Charter. As part of the monitoring activities, there is a reporting procedure that requires states to submit a report to the committee every 3 years. Similar to the African Commission, the committee can receive communications from persons, groups, or NGOs regarding violation of the Charter. In addition, the committee has been granted broad powers of investigation. It can be stated that the AU Act confirms the importance of human rights by the adoption of guiding principles such as gender equality, participation of the African peoples in the activities of the Union, social justice, peaceful coexistence of the member states, and respect for democratic principles, human rights, the rule of law, and good governance. Thank you.